Leslie, and we've got King with us, and also my hubs, Steve. But Bill is in the car for a little while, he says, so he's going to be joining us hopefully in a bit when he gets to a place where he's going to be able to talk better. So hopefully you guys can hear me. If you can hear me, wave at me. King, can you hear me?
Loud and clear.
Fantastic. Steve, are you there? Can you hear me?
Yeah.
Okay. And can you and King hear one another?
Yes.
Yes.
Okay, great. Okay, so I think we might as well go ahead and get ready. Yep, okay, people are waving at me. Great, fantastic. Thank you. So the audio is sounding good, hopefully, tonight. Um, we had, just so folks know, we had some trouble with the audio transmission last week on Sunday, and the speakers could not hear the problems. Everything sounded clear to us, and the recording was clear when it came to me and when I posted it up again. So just so you know, if there's cutting out, if there's drops, if there's that kind of thing, um, the recording apparently doesn't take any notice of those. It seemed like it was a problem on Twitter's audio transmission. It was not a problem that any of the speakers or the hosts could have fixed. So hopefully that won't happen tonight. But if it does, and you don't, it gets too wonky to listen to, then obviously I will be posting out the recording again tomorrow morning. In any event, so if it gets to be too bad, drop off and you can listen to us tomorrow. But it's sounding clear to me so far tonight, and I'm not getting any comments. If there are comments with the audio, if there are problems with the audio, then drop me a comments in the comments section, chat to this spaces, so that I will know about it. Okay, so with that, we're going to go ahead and get started. And tonight we're talking about the immunity case that is in the Supreme Court. It's going to be argued on Thursday morning. I believe that's the only argument set that day. They specially set it. It's a fast argument. Steve, can you comment on that? Because the procedure here is that the the former president, and then the special counsel also asked the Supreme Court in December for a stay, and for the special counsel wanted the Supreme Court to go ahead and take the case at that point and not let the Court of Appeals rule on it. They didn't do that, and the Court of Appeals did rule on it. But then the Supreme Court turned around almost immediately after the Court of Appeals ruled and said that they would take the case. And so now here we are hearing the argument on the merits in toward the end of April, when the original paperwork, I think, was filed with the Supreme Court at the end of December. So give the folks an idea about whether that's normal or fast or slow or whatever.
Well, that's a very expedited procedure. Normally, you wouldn't expect a case that it could come up at the same time frame as this one did to go before the Supreme Court until the next term, meaning next fall or next spring. But because of the significance of this case, and because it's a criminal case, and because it's prior to trial, the court expedited the process.
Okay, so some of the hurry up in that case is attributable, we think, right, to the fact that it is an interlocutory approach to the appellate courts before trial in a federal criminal case. Most federal criminal cases are heard by the courts after the jury renders a verdict, not before trial. And so there would have been a certain amount of hurry up anyway because of that, right?
That's right. We've discussed this before. The general rule is that appellate courts, including the Supreme Court, really do not like interlocutory appeals. In other words, appeals before there's been a final decision in the court below. And their general view is if you think there have been mistakes made, just keep track of them, and we'll deal with them when and if there's a conviction or an adverse judgment against you. They do that to avoid piecemeal appeals, which would greatly multiply the number of appeals that they've got to deal with. And they are very resistant to allowing what lawyers call interlocutory appeals. And this is even more so in criminal cases than in civil cases. So here we're talking about really an exceptionally fast track. And that's driven by the fact that it's a criminal case and by the fact that it's such a high profile and significant
Right. So my own view is that some of the hurry is generated by that it would have been an expedited case because it's a criminal and interlocutory appeal. And that accounts for some of it, and then some of it is because of the high profile nature of the case. I think it's kind of a combination of both. Okay, so to back up for a minute and let people know what are we going to be talking about? We are only going to be discussing tonight because there is so much to talk about just on this one topic. We're only going to be talking about the argument in the Supreme Court, which is Thursday morning, which is brought up in the context of the federal criminal prosecution of the former president in D.C., brought by the special counsel Jack Smith on the indictment in D.C., which charges 4 counts. That's the context in which the argument is being raised. The results of the argument, and we're going to talk about this as we go along tonight, the results of this argument, the opinion that the court renders, I think will probably apply both to that case in DC and possibly, in fact, probably, also to the case in Florida. But technically, procedurally, this argument of immunity is not in the Supreme Court yet in the Florida case. It could be, but the Florida judge's rulings on immunity came after this case, I think after the case had already been set in the Supreme Court. So it will, I think, apply to the Florida case, but technically it's only being brought up as part of the DC case. So we're not going to talk about other issues with the Florida case. We're not going to talk about really other issues even with the DC case, of which there are many. We talked about some of those last week in the Fisher case that they heard about one of the statutes that's in the indictment in this DC case. But what we're going to focus on tonight is the argument that the former president has raised that he has immunity from criminal prosecution for his official acts while he was the president. And as I said, that the decision they ultimately render on that will apply to more than this case, but it's being raised in the context of this DC case. So those of you who have asked questions on the Twitter about the effect on the Florida case, we are going to talk about that, but we're not going to talk about other aspects of the Florida case like the Presidential Records Act and the declassification and all of that stuff. We're going to save that for another day when we focus on the Florida case. So to let folks know what happened, I think as everyone knows, the former president was indicted last summer on 4 counts by the special counsel in D.C. And that case was assigned to Judge Chutkan. She made some rulings, pretrial rulings in the case, finding that the former president did not have immunity for official acts, immunity from criminal prosecution for official acts. She said there was no such immunity. And the former president disagrees with that, obviously, and so he appealed that case to the D.C. Circuit Court of Appeals. And as I said previously, the special counsel tried to get the Supreme Court to jump the Court of Appeals and take the case away from them, but the Supreme Court declined to do that. The former president had asked for a stay of the proceedings in the district court for the Court of Appeals to review the case and decide what they thought about it. The Supreme Court, once the Court of Appeals made its ruling, which we're going to talk about, then basically treated the papers that the special counsel and the former president's lawyers had filed asking for the stay, asking to jump. The court basically treated all of those as a petition, a normal petition for cert. So in the normal course of the procedure, after a trial or even on pretrial rulings, lawyers would file a petition in the Supreme Court. It's called a petition for certiorari. And basically you are asking the Supreme Court to hear your case because there are very, very, very few cases where you have a right, an absolute right to be heard by the Supreme Court. Most of their docket is cases that they agree to hear. And so what you do as a lawyer is you file a request for your case to be heard called a petition for certiorari, and then the other side can oppose your request. Sometimes they waive their request. They say, we're not even going to bother to answer this because it's so dumb. When they do that, sometimes the court still asks them to submit an opposition. But most of the time, if the other party waives, then the court says, fine, you don't want to comment on this, we're still going to decide on it. But at that stage, what the court decides is whether or not they're going to take your case. And then once they do that, then they give you a briefing schedule where you then brief the actual issue that you've asked them to hear. And sometimes, as happens here, when the court decides to take your case, they say in their order that says they've accepted your case to be heard, they say what issue or issues they are willing to consider. And they did that here. So I posted on the tweet that sets out the spaces for tonight, I linked a tweet that has the specific question that they asked the parties to brief. And that is the only thing they're going to consider on Thursday. So at that point, then the both parties filed their briefs. When you are the petitioner in the Supreme Court, you file your opening brief. The other side files a responding brief, and then as the petitioner, you have a right to file a reply brief. And then, as is common in Supreme Court cases, a bunch of other people come in and they file what are called amicus briefs. Amicus is a Latin word for friend, and so the briefs are called friend of the court briefs. These are briefs filed by other groups that want to tell the court something about the case, how it might affect them, like an industry or a trade group or the ACLU, or other civil liberties groups might chime in and comment on a case that involves free speech, for example. And so they're not parties in the case, but they file briefs to kind of help the court make its decision, bring things to the court's attention that the court might not otherwise think of, that they might not know about if it's like an industry specific kind of case. And the court takes all of that into account and then makes a decision. So at the stage that we're at now, all of those briefs have been filed. Presumably the justices and the clerks have read them all, and they're going to hear the argument on Thursday. Now, I think we've said this many times, but I'll say again. Usually the Supreme Court, when they take a case in a term, which the terms run from October to the following June, if they hear the argument in the term, they usually decide the case before or by the end of June. June 30th was traditionally the last day that they would issue opinions. In more recent years, especially with the pandemic, they have sometimes slipped a little over into July, but traditionally June 30th was the ending date. And so because they're hearing the case this week, they will probably decide it between Thursday and June 30th. Now, they can do whatever they want, like they've expedited this case faster than the normal schedule because they want to hear it sooner. And so if they want to take longer to decide the case and issue their opinion, then that's what they'll do. And they're the Supreme Court, so they can do whatever they want. But probably we're going to get a decision from them on this issue about the immunity by the 30th of June. And then once that drops, it will then start to have the ramifications and effects on this case and the other cases and potential trials for those cases. And so we're going to talk about those effects when we talk about what we think they're going to do. Okay, so procedurally, that is where it is at. And procedurally, like I said, the Florida case is not technically before the court yet at this time, but that doesn't mean that the decision won't have an effect on the Florida case. Okay, so King, I know you've read all these briefs, and so let's start with kind of sort of big picture. What did we think of the briefs? Now, bear in mind that these lawyers both on both sides have had nowhere near the amount of time that you'd usually have to do this kind of high-level lawyering. So we will cut them all a little bit of slack, I think. But other than that, what did you think of the briefs?
I thought Trump's briefs were really good. I was not as impressed with Smith's brief. I have not read the amici brief, so but that's just my my reaction as a lawyer used to writing briefs. But before you get there, Leslie, I
Yeah.
think it's helpful to give everybody an understanding of how complicated the criminal law is when you try to apply it to the president, particularly in this case. No,
Right.
everybody, the common perception is Trump is accused of committing a crime and trying to overturn an election. It's akin to treason or murder, something black and white, uh,
Bribery, right?
something
Something clearly defined.
easily
Hmm.
defined and easily proved. That's not the case at all. There's no such crime as overturning an election. Uh,
You mean like collusion? You mean like
he,
there's no such crime as collusion?
that specifically, he's been charged with violating three statutes. One of which the Supreme Court is going to decide, as we talked about at our last session, uh, what it means, how extensive, what its scope is, whether obstructing an official proceeding includes what happened on January 6th and the lead up to January 6th. Um, that's an that's an issue that's never been decided before. It's not spelled out that way in the statute. To read the statute that broadly, it would encompass an infinite number of ways to screw up whatever Congress is trying to do. Uh, that's the second statute. Um, I'm going to skip over the second one. The the third statute is conspiracy to uh, violate somebody's rights, their constitutional rights, and in particular their voting rights. The charge is Trump.
Hey,
Yes,
Kingmaker, let me ask you to pause for a second. There's a lot of noise where you
that
are. Are you
I'm
moving
shuffling
around?
papers. Okay, I'll
Yeah,
try to
okay,
stop that. Uh,
okay.
Trump he did knowingly combine, conspire, confederate, and agree with co-conspirators to injure, oppress, threaten, and intimidate one or more persons in the free exercise and enjoyment of a right and privilege secured to them by the Constitution and laws of the United States, that is, the right to vote and to have one's vote counted. That's what the law that tracks the language in the law. But Trump as president is charged under the Constitution with the obligation and authority to uh, to see to it that the laws passed by Congress are complied with and enforced. And that particular law he's charged with makes it a crime to stuff a ballot box with forged ballots, to prevent the official count of ballots, to destroy voter registration applications, to destroy ballots, to exploit the infirmities of elderly, old people by casting absentee ballots in their name. Uh, it's also a crime to illegally register voters who not and cast absentee ballots on their behalf if they're not eligible. It's a crime to fail to count ballots or to alter votes counted. It's a crime to steal votes by changing votes cast by voters at voting machines. All of the things that Trump claimed were happening in this election. And it's his job as president and head of the executive department to see that those laws are enforced. So, on the one hand, you've got the prosecution saying, Trump, you're a criminal, you violated people's voting rights. And his defense is, I was acting under authority of the U.S. Constitution, doing my duty to make sure that others didn't violate that same law. And then the other law he's accused of violating is conspiracy to defraud the United States. And you can go back to 1910, uh, the first Supreme Court case that construed what it means to conspire to uh, uh, have a conspiracy against the United States to defraud the United States. I'll quote the court. The statute is broad enough in its terms to include any conspiracy for the purpose of, and these are the key words, impairing, obstructing, or defeating the lawful function of any department of government. So if you conspire to impair or obstruct or defeat a lawful function of government, you violated that statute. Again, the other side of that is Trump argues or will argue that I wasn't conspiring to defeat anything. I was I was doing my job as president, part of my duties under the Constitution, to see to it that the laws were in effect and enforced by the Department of Justice, that all uh, allegations of fraud in the election were run the ground and thoroughly investigated. And if we found, to the extent violations of law were found, that appropriate remedies were put in place. And specifically as to what happened on January 6th, Smith argues that that one of the functions of the governmental functions that Trump impaired or impeded uh, was the congressional function under the Electoral Count Act to count the uh, votes of the electors selected by the vote in 50 states. Receive the certified votes, count them, and the winner, one with the most votes, would be the next president. Uh, again, that statute has provisions in it that only that that make only certain votes conclusive. They have to be counted when they're received by Congress, and those are the votes that have been where the election has been all contests or disputes about the election have been finally decided under state law prior to the safe harbor date, which in 2020 was December 8th, I believe. 8th.
6th. It was,
And
yeah, right.
I
8th or
believe it
ninth.
was the
Yeah.
8th. And if a state hadn't finished counting or deciding who won or finally determining all pending disputes through court actions, things like that, Congress was not, it was not conclusive when it got to Congress. Whoever came out or whoever was in the lead when it went to Congress. And it was up to Congress to figure that out. And the Electoral Act, Count Act, specifically called for permitted objections to be made by any tendered certificate of electoral count by a state. And in historically, the and in the act contemplates that non-certified uh, slates of electors would be before Congress to decide if they should have been certified. So
Instead.
instead.
Right.
So it's a the act itself contemplates a procedure whereby Congress sets here's objections, here's debate, and decides which candidate won in the contested states. And and
Right.
so Trump's
So,
argument is going to be, well, look, when all of that is consistent was with what I was asking Congress to do, either,
and the vice
and,
president and
and
so
so
forth.
forth.
Right.
So you have a dialogue, a debate here that's never been decided by the Supreme Court as to what's his official duty in this respect and what's not, and how do the criminal laws apply to what he did? That's the context
Right.
in which the Supreme Court
Right.
is going to hear
Yes, I agree.
the immunity.
So, right. Right. So if we to encapsulate what you're saying, so if we sort of back up, the prosecutor is saying you broke these laws by doing X, Y, and Z. The former president is saying I wasn't breaking the law, I was enforcing the law. Both of them seem to agree that he was doing the things that the prosecutor has a problem with, right? And there's no dispute about that. The question is, were those actions lawful or not lawful? And, you know, the special prosecutor, Kingmaker, you got to mute yourself there. There's a lot of noise there. Um, the special prosecutor's view is one way, and the former president's view is another. Um, but you correctly say that kind of the bigger picture overall problem is two competing narratives about what was following the law and what is not following the law. And when you are trying to construe criminal statutes against the President of the United States, who is a unique constitutional actor charged with unique responsibilities under our Constitution, that you've stepped into the morass, right? So the Supreme Court is going to try to straighten that morass out on starting on Thursday. Um, but yes, thank you, King, for sort of reminding us like these are the operative laws at play against which the Supreme Court is going to try to figure out what to do about this question of immunity. I'm getting a lot of feedback on my headset. Are you guys hearing that? Does it sound muddy?
Not to me.
Okay.
It's fine. I hear a faint background noise, but it's not a
Hmm.
feedback.
Right. Okay. All right, great. Okay, so let's turn to okay, this is the issue is joined, and let's talk about what the advocates have done with their opportunity to present their arguments to the court. So I will say for my part, Kingmaker, that I agree with you. I was not impressed with the special counsel's brief. I thought that Trump's lawyers' uh, briefs were very good. Um, you know, they're probably not maybe quite to the level that you would typically see in the Supreme Court briefs in some ways, not others. But I think that's a consequence of the foreshortened amount of time that they had. But still, taking that into account, I was very impressed with the way their briefs read. Um, but let's turn to Steve and ask him. Steve, what did you think of the briefs themselves?
I generally agree with that assessment. Um, I'd like to frame the issue for a couple of minutes here. Um, and that is that the Supreme Court, as you pointed out, has framed the issue before it as being whether the president has immunity for an official act. And both parties agree that a president can commit official acts and that he can commit private acts. And both parties agree that he is not immune from criminal prosecution for his private acts.
Right. It seems like they're going to disagree about where that line is between the two.
Right. But the question the Supreme Court has said it wants to decide is, assuming that it's an official act, does he have immunity for it?
Right.
And to me, it's very interesting in this way. As many people listening on the conversation tonight may know, the Supreme Court decided 40 years ago in Nixon v. Fitzgerald that the president has immunity from civil actions, civil lawsuits for his official actions. And so a common sense approach would suggest, well, if he's got immunity from civil lawsuits, why wouldn't he also have immunity from criminal lawsuits? And the logic to that is obviously very powerful. The answer is that the Constitution doesn't say anything in particular about civil actions and immunity. But the Constitution does say something about criminal actions, and in particular, it says, and let's see if I can bring up the provision here. It says in Article 1, Section 3, Clause 7, which deals with the powers of the legislature of Congress, it says that it talks about impeachment, and it says that judgment in cases of impeachment shall not extend further than to removal from office and disqualification to hold and enjoy any office of honor, trust, or profit of the United States. But the party convicted shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to law. So the Constitution itself, in the case of criminal charges, specifically contemplates that a president could be criminally indicted, charged, and convicted. But it suggests, and this is one of the big issues that the parties debate, but the language read very strictly suggests that the president can only be charged and convicted for an official act if he has first been impeached and disqualified from office. And that is indeed the position that Trump's attorneys take. They say, since that hasn't happened here, then if it's an official act, Trump simply can't be prosecuted for it, nor could any other president. The only way you can prosecute a president for an official act is that if Congress first impeaches and disqualifies the president. So that sort of frames the issue.
Right, and let's talk about that for a second, because the media has done a very bad job of framing the issue or explaining how the court is framing the issue. So that folks understand, the media has sometimes, and liberals, commentators have sometimes framed the issue as, well, what you're saying is that it would put Trump or any president above the law. You know, he could violate any law, he could break any law, he could murder his wife, he could do this, he could do that, and never be prosecuted. And the answer is no one is arguing that. No one, not a single person. Because the question is about official acts, not private acts. There could be a question, of course, about whether an act which category it falls into, private or official. But no one, including Trump's lawyers, are arguing that a president could commit a private crime, such as murder, such as bribery, and not be prosecuted for it in the criminal courts. Now, I suppose there could be a question about whether that could be done while he's a sitting president. And everyone knows that the office of, because it's been bandied about 100 million times by the Mueller people and others, that there is an opinion by the Office of Legal Counsel that a sitting president cannot be indicted, that you would have to wait until after he left office. But that would then run right into what Steve was just saying, which is that, okay, but if he got impeached and then convicted by the Senate and tossed out of office, then you wouldn't have to wait till his term ended, because his term would end by operation of impeachment. So the two things sort of work together. But focusing just for a minute on private acts versus official acts, the question that the Supreme Court said it wants to have answered has to do only with official acts. So a lot of these silly hypotheticals that people are tossing around about, well, the president could shoot someone, as the former president himself said, on Fifth Avenue, and that wouldn't be a problem. That is not what the issue is at all. The first hurdle is the act in question an official act or not? Now, in this case, the special counsel has conceded in its briefing that some of the things, at least some of the things that are alleged in the indictment in this case, are official acts, not private acts. So that then puts squarely the question before the courts. This is the way that lawyers look at it. There is a question on the table that we're trying to decide. The question is, if it is a given that the act in question is an official act, is there immunity or is there not immunity? And the lower court, Judge Chutkan, and the DC Circuit judges said there was no immunity for a president, even for official acts. And Trump's lawyers obviously don't agree with that. So the Supreme Court's now going to have to decide that issue. But what's interesting is the various rationales that both the courts and the special counsel are trying to use to say that official acts are not immune. Because on its face, that just doesn't seem like it can be the right answer. So, for example, other uh, officials, judges, prosecutors, law enforcement officers, members of Congress are immune in a general sense, one to one extent or another, are immune for their official acts. There's different tests depending upon exactly what it is, but nowhere else in the law is it just an absolute prohibition that there's no immunity for official acts. So, on its face, that seems like it can't be the right answer. And so, what I see in both the lower court decisions and in the special counsel's briefs is they seem to be struggling for arguments as to why that makes sense. And so, one of the arguments that they raise, and so Kingmaker, Steve, I want your views on this. And Ship too, when you finally get someplace you can talk, join us if you
He
can.
he's
One of
on
the,
here as a listener, I see.
yeah, he said he was going to have to listen for a while because he's driving. Um, but one of the arguments that was made in the Court of Appeals, which I have said publicly, I think this is the most nonsense argument that I have ever seen from a Court of Appeals, is that somehow the president is immune up until the moment he leaves office, and then the next minute, January 20th, 12:01 p.m., he or she becomes no longer immune for things that happened while they were president. So they're using that to say that since Donald Trump is obviously not the current president of the United States, that he therefore is no longer immune. So let's start with that. What do you guys think of that argument?
It I read that kind of amazed at the logic of it. It
Right.
it I don't see how the court can end up holding that without either reversing or severely limiting Nixon v. Fitzgerald. So
Right. And so folks know that Nixon v. Fitzgerald is the case Steve was talking about. It's from 1982. So yeah, go ahead, King. Right. That I don't see how
yeah,
either. Because why? Tell us what's the
well,
rationale
the
there.
Nixon v. Fitzgerald, uh, that was a civil case against Nixon, President Nixon. It was not a Watergate case. It was a case by uh, uh, an employee uh, of the executive branch. Uh, I think Army or Navy or Air Force. I forget which. Uh, he was uh, a bureaucrat subject to civil service and civil service protections. And he was fired, and he claimed he was fired because he gave whistleblower testimony to Congress. And Nixon stood up and took responsibility. He said, all these other people may have been involved, but it was my decision. I did it. Sue me if you have a problem. So he did. He sued Nixon ultimately. And this was long after Nixon had left office. Uh, so the circumstances are the same. You have a former president who's being sued civilly for damages, and the Supreme Court in that case went through the basically the common law notion of immunity and held that you need to protect both acting presidents and former presidents from harassment, suit, damage claims, politically motivated lawsuits, anything that might inhibit his ability or motivations for conducting the affairs of the state when he's president. You can't have
Right. So basically, why do we want to have the Damocles sword hanging over the person who's running the country? That makes no sense. that would impair the office of the president. Forget about the person sitting there in the chair, right? So, yeah, so I, like you, I read this with amazement. Like, oh, okay, well, how would it not still cause the president to be fearful of doing whatever he or she thinks is the right thing if their immunity magically disappears the moment they take off in Air Force One from the White House lawn after the swearing in of the new president? That just seems crazy to
Well,
me.
I'll put my special counsel's hat on and give you the answer.
Okay.
The answer,
All right.
Leslie, you should know. You're a lawyer. You should know
Oh.
that we're talking about criminal responsibility, not civil. Civil, anybody can sue. Any citizen of the United States who alleges
Mm-hmm.
damages can bring that suit, and there are no limits or restrictions on their ability to do so. In the
Right.
in
If you can type it up and file it on the electronic
the,
filing, you can
right,
sue the
yeah,
president.
it costs you $50 or something, but
Right, whatever.
criminal is another animal because
Mm-hmm. Yeah.
we have protocols and rules within the
Mm-hmm.
Department of Justice, and we have grand juries.
Responsible public
Yeah, we have
prosecutors,
grand
right?
juries that stand who
Uh-huh.
protect the misuse and abuse of criminal prosecutions against former presidents that some people might claim is politically motivated. That will never happen.
Right,
That's
right,
literally what they argued in their book.
right.
Yeah,
And it's in,
let me pick up on that if I could. I
go
mean,
ahead, Steve.
in their summary of argument, the special prosecutor says that Nixon v. Fitzgerald does not extend to criminal prosecutions. And the reason why, and now I'm going to quote them, this is literally out of their brief. This case involves the far weightier interest in vindicating federal criminal law in a prosecution brought by the executive branch itself. This was not true in Fitzgerald. On the other side of the ledger, while the Fitzgerald court was concerned about the potential that a multiplicity of private civil actions would chill a president's decisions, the same concerns are not present in the criminal context. Close quote. Now that, in light of what's happened in the last couple of years, is indeed laughable. Because if there's one thing that the history of the last couple of years has taught us, that you want to talk about a multiplicity of criminal actions, look at Donald J. Trump.
Right. What he means by that, folks, is, four different prosecutors have come after him. For the special counsel to say that, oh, well, that's not something that would happen is just absurd in light of current events. At the moment, the Supreme Court is hearing this argument. The former president is literally on trial in New York State court and is prevented from even coming to hear the argument in the Supreme Court. So I just don't understand how, they're just not laughing their way through some of these arguments.
It's astonishing that the special prosecutor, in some ways, it's astonishing that they made it. They made it because they feel like they have to, and they might as well embrace it if they're going to make it. But there's got to be at least 6 members of the court that read that and guffawed.
Right, exactly. So, all right. So the rationale in Fitzgerald is we don't want lawsuits chilling the president's decision amongst varying competing choices that he or she has to make when you're tasked with the awesome responsibilities of the president of the United States. So, given that that's the rationale in Fitzgerald, right? To me, that rationale overtakes this argument by the special counsel that, well, civil suits can be brought by any Joe knucklehead, whereas criminal suits would only be brought by responsible prosecutors. I still think, okay, but what difference does that make? Because the president will still have to consider that then whenever he or she is making important decisions that face the nation. And why do we want the president worrying about whether Fannie Willis or Alvin Bragg is going to indict him or her when they're trying to decide things that that they're the representative of the entire nation and we need them to decide. So that argument to me, it's kind of like apples and oranges. Hey Ship, can you hear me?
You stumbled into the truth. That was
Yes.
exactly the
I
point.
stumbled into the truth. All right, go with it,
The,
my
the,
friend. Well,
the
how's
issue is not who would trouble the president in the future that
Right.
might
Yeah.
influence decision making in real time. The issue is that the president fears being troubled in the future when making decisions in real time.
Right. Right.
The,
Right.
there's another issue that is worth discussing, and I'm sure the court will bring it up in argument on Thursday. That is a one relating to the structure of our Constitution and separation of powers. Uh, it goes like this: the and it goes all the theory goes all the way back to fundamentals of constitutional law, beginning with Marbury versus Madison, which Justice Marshall back in the early 1800s explained that the way the Constitution is structured, the executive branch headed by the president is the framers wanted him to be unfettered by anything but the Constitution. They did not. They precluded both the other two branches, Congress and the judicial branch, from interfering with or getting in the way of his exercise of his power and authority, where the Constitution gave him discretion on how to exercise that power and authority. So if there were anything that he had the discretion on what to do, for example, who to what where to put your uh, uh, uh,
Post
post office,
office.
where, or
Right. Right.
how to do the hiring and firing within the executive branch, who to hire and fire, what what criteria do you use to enforce criminal laws? Uh, where do you put where do you invest the country's resources to carry out the laws and enforce the laws, etc.? That's those are things left to the executive's discretion, and for Congress to second guess it by calling some portion of that criminal or not uh, is basically violates the fundamental tenets of separation of powers. And
Right. Much less the courts, for crying out
it,
loud.
well, Congress, by passing a criminal law that interferes with and infringes on the executive's authority to have discretion in certain areas, and then the courts, by the same token, uh, uh, putting former presidents in jail because after the fact, a jury decided that exercise of their uh, uh, the powers of their office uh, was a crime.
Right. So, you know, this this idea that the president has all these responsibilities flows from what's called the vesting clause of the Constitution, which says the powers of the executive powers of the United States are vested in the president. This is a point that in a lot of these cases, what you see is the other side does not like this idea. They just cannot accept, they rail against the idea that the president is a unique constitutional actor. He or she is not like any other person in this country, whoever the current president is, in terms of the law. They represent, embody the United States in a way for some purposes. They clearly embody the entire executive branch for other purposes. And so, to, for example, this vesting clause, based on this old case, Marbury versus Madison, this is one of the first cases, you guys, that young lawyers in law school learn in constitutional law, Marbury versus Madison. And one of the ideas in that case is that the president cannot be questioned by the other branches uh, particularly the judiciary, for his decisions that he undertakes in the scope of his office. The courts have taken this so seriously that when XYZ person sues the federal government for violations of law or for improper regulations or all kinds of things, you cannot sue the president. You have to sue one of the people who work for the president. The president himself personally cannot be hauled into court to answer for the acts of his administration. So you don't sue, Bill Clinton. You sue the secretary, whoever his secretary of state was. I can't remember off the top of my head. Right? You don't sue the president. You sue the cabinet official who's the head of the department that's undertaking the various activities. And so from this way of looking at it, and Trump's lawyers argue this very effectively in their brief, from this constitutional perspective of the office of the presidency and the person of the president, the idea that you can't even sue the president, but somehow you can indict him just seems insane. And Trump's lawyers really, I thought, effectively argued this question of the vesting clause for official acts.
Yeah, but I want to note that there is at least one exception to that the Constitution itself provides,
Right,
and that is impeachment.
right.
Now, Trump's attorneys pick up on that too, and they do acknowledge that that's an exception. But basically, they say that's the only exception. They say under Marbury that the president isn't accountable to the judiciary for his official acts, except if he is impeached and turned out of office by the Congress. At that point, he could become accountable in courts. But short of that happening, if it's an official act, that's the end of the matter. The courts can't touch it.
And so you guys know, Trump's lawyers did a very good job in their brief referencing the Federalist Papers, right? And the early documents of near the founding of the Republic about what were the founding fathers talking about this for? Why were they saying that? I mean, there's, good quotes in there from the founders saying, look, the president is responsible to his country and his conscience, right? Not to the law in the same way that other people are. So this idea of the vesting, to me, and we're going to get to the impeachment in a second, but to me, the vesting clause arguments is the answer to a lot of the arguments that the lower courts raised and that the special counsel raised, in which they're saying, well, but here Trump's purpose was to try and stay in office, right? Or he had a bad motive for doing this. Even if you're trying to say he was somehow trying to enforce the law, he was doing that for his own reasons, not because he's actually carrying out the law. And I just see those arguments as being inconsistent with the idea of what the presidency actually is. What do you guys think about those arguments where they're basically focusing more on motive than on acts? And how do we think that the justices are going to accept those arguments? And I will note, Steve, remember the case, was it last term or 2 terms ago, about the census question, where Justice Thomas, for example, he was just adamantly against, we need to look into the mind of these government officials and figure out what their real reason was for doing things, as opposed to looking at whether or not they had the legal authority to take these actions. So let's debate that. What do we think, you guys?
My opinion is, and I think there will be justices express it this way. The idea that we can that a future executive going after a former chief executive can second guess motives or try to use what's inside the former president's head and call it criminal is a step towards tyranny. Because, as I said in describing the context of this argument, you have a law on the books that makes it a crime for individuals to deprive other citizens of voting rights by switching votes and whatnot. And one of the allegations in the indictment is that uh, Trump conspired with a certain person in his Department of Justice, talking about Jeff Clark, who was head of
Right.
two civil divisions. He was head of the Civil Rights Division and the Civil Litigation Division. Uh, and in both instances, matters came across his desk relating to whether this particular law was violated. And he had an opinion that it might have been. And he wanted the DOJ to investigate. And he drafted a letter to the election officials in Georgia recommending that they investigate further because we here in Washington have some evidence that the election laws might have been violated. He is promoting further investigation because he has found evidence of fraud and irregularities. Well, his compadres in the DOJ had a different view. They didn't think, one, it was the DOJ's business, and two, they didn't agree. They didn't see the same indications of possible fraud that Clark did. So they had a dispute within the office, within the DOJ. Uh, it was and but for being leaked to the New York Times, nobody would have known about it. And they went to President Trump to get his view on it. This indictment incredibly charges Trump as in being in league with this unindicted co-conspirator Clark to deprive citizens of their right to vote, when what the subject of the meeting was, were there violations of this law in Georgia that need to be investigated. So right there you have it like it that kind of brings it to a head. Was Trump was he following the law, following the Constitution, and using the power of his office to make sure the laws were enforced? Or did he have a secret plan with somebody in his office in the DOJ to break that very law that he says he was trying to enforce? And to determine that, we're going to let a jury get inside his head. That's the kind of factual issue that I would, I think, honestly, would turn most judges away, because it steps upon the very fundamental nature of what the president is and what he's supposed to be doing.
Okay, Steve, what do you make of this idea? Almost like pretext kind of argument that, well, he was
Oh,
doing X, Y, and Z, but not really for that reason.
Well, the Trump's brief has a couple of good quotes. They argue that immunity does not turn on, quote, the motivation for actual performance of official acts, citing a Supreme Court decision called Brewster. And then they say, and again quoting from another decision called Johnson, the claim of an unworthy purpose does not destroy the privilege. Uh, and from still a third case, they say immunity, quote, would be of little value if immune officials could be subjected to the hazard of a judgment against them based upon a jury's speculation as to motives. So what what there is, and you adverted to it earlier also in the census case, is that the judiciary is very reluctant to second guess the motivations of the executive branch or the legislative branch for that matter in terms of taking the official acts that they do. Now, there's no question that we're in a highly political context here. We're talking about the election. And clearly, all of these actions were things that Trump had a big interest in. But the whole notion of immunity is that if it's least generally as it's been applied, and as they talked about it in the context of immunity from civil action in the Nixon v. Fitzgerald case, the court said, look, if it's even arguably within the outer limits of an official act, that's the end of the matter, because we don't want to get into these sort of debates about what their motivation was. That's bad business. And, you know, and you always, these cases come up in a particular factual context, and people say, oh my God, it's completely clear, you know, that Trump this was his motive and it was no good, or that Nixon's motive was this and it was no good, or whoever the president you're talking about. But the court takes a much broader perspective than that, as they need to. And they say, this is very bad business for us to be getting into, and we don't believe the framers meant for us to get into this, and so we're not going to go there.
So let me ask you, Steve, to tell the folks about how that principle has been applied in the context of members of Congress. There's a case here that's very prominent, or well known in the D.C. Circuit, but I'm not sure that it's well known in other areas. Do you know what I'm talking about?
Yeah, you're talking about the Rostenkowski case.
Yeah, right. Yeah. So tell them about Rostenkowski.
Rostenkowski was a prominent Democrat from Chicago, and I think was head of Ways and Means. I forget exactly what position he held, but he was extremely powerful. He'd been around a long time. He was also widely liked within Congress, but he got criminally indicted, and the allegation was that he put people on his official payroll, his congressional payroll, who didn't do any official duties. They just, you know, were personal gophers for him, who did his bidding on, you know, personal business and political business and this, that, and the other. And the D.C. Circuit, and some Republican judges too, this was not a partisan decision at all, but the D.C. Circuit was going to have nothing of that. They said, no, we are not going to second guess what's political and what's official, or what's personal and what's official, unless it's absolutely clear cut that it couldn't possibly have any official connection. And they said to let a case go forward where you could do that would be an invitation to what they called mobocracy, and after the fact, mobocracy at that. And that description, I think, aptly applies here when they're asking juries to judge the motivations of President Trump after the fact. And in particular, then you get into the whole issue of the jurisdiction that they're in. And of course, in this case, they're in D.C., which is heavily Democratic and where Trump is not at all popular. And so they're asking a jury of 12 drawn from D.C. to decide after the fact whether his motives were pure or impure.
That raises an issue that I think that the justices may get into, is whether a criminal trial of any former president for anything involving his official acts can ever be anything but political.
You think they'll take that into account in terms of the immunity?
I think they have to.
Okay. Well, somehow Ship has dropped off as a speaker. Ship, I've sent you another request, so hopefully you can click on that and get back in, because I'd like to have your view on that too. Okay, so basically the former president's lawyers are saying, look, the president is vested with these powers, and therefore it doesn't make any sense because of that constitutional provision, and the history and the precedents and so on, that he could be indicted. But everyone seems to agree that as I said, they definitely agree that private acts could be prosecuted, although perhaps not while the president is still in office. But there is this second exception that Steve keeps adverting to, which is on the impeachment. So again, here I want to point out that the press and some of the folks on the left have not clearly articulated what Trump's argument is. His argument is not that a president would have to be impeached and convicted by the Senate for any conduct in order to be prosecuted at all, public, private, it doesn't matter. No, their argument is narrower than that. And they're relying on a specific provision in the Constitution that talks about the what the scope of the impeachment is, which Steve read to us already. So it is limited. Their argument is that it is limited to the acts that the president would otherwise not be able to be prosecuted for, meaning official acts, because they concede that he could be prosecuted for private. So his lawyers' arguments are because of this language in the Constitution that a person convicted by the Senate on an impeachment charge could still be liable and subject to indictment in the criminal courts, is obviously what it means. That means that that's the sole exception for when official acts can be prosecuted, not private acts. So the special counsel's rejoinder to that seems to me to be very muddy. I'm not sure they don't like this plain language, which of course several of the justices probably will gravitate to. But what did we think of the sort of the rejoinder to this position by Trump? Has anybody got any comments on that?
The Smith's brief essentially argued, well, it doesn't say it's the only way you can be prosecuted. Therefore, he can be prosecuted, whether he's impeached or not, impeached and convicted or not, since it doesn't say only. Uh,
Trump's people are arguing that it's the logic of it,
yeah,
right? That if it does say you can convict the one, but it leaves out the other, obviously, then that means the other one can't be. It's kind of like by operation of logic.
I think Trump has the stronger argument there, particularly when you view it in light of the structural impediments, a la Marbury v. Madison, that prohibit Congress and the judiciary from interfering with the executive's exercise of his powers.
Right. Steve, do you have anything you wanted to say about that part?
Yeah, the special prosecutor argues that the text, the structure, and the history contradict Trump's reading of the impeachment clause. Now, the text and structure, they get into grammatical arguments where which are stretches, and then on the history, they make their argument, but in the reply brief, Trump's attorneys come back and say, no, you want to talk about history? Let's talk about history. And they point out that that Congress, well, I'm sorry, not Congress, the framers in the Constitution said if there was conviction in the Senate, then you could be indicted. And that they say, the special prosecutor's trying to say, oh, conviction doesn't just mean conviction, it could mean if you're charged. But they say, no, the history doesn't suggest that, because if you look into history, two states after that in the early 1800s, Pennsylvania and New York, had provisions in their constitution that were similar to the U.S. Constitution about impeachment, and they explicitly changed those provisions to broaden them so that you could prosecute an executive who had not only been convicted, but who had simply been charged. So they said, all right, if you want to look at the history, this is the history of it.
Right. So it appears to me that they just simply don't like the plain language of this section, which has to mean something. It clearly says that if the person was convicted by the Senate, that they can be charged, which by negative implication, by operation of logic, seems to say that if that hasn't happened, then the person can't be charged. So that seems to be why you see these arguments from both the circuit judges and the special counsel about purpose, motive. Well, those rules really shouldn't apply when this person's doing this for a reason that we don't like. It's almost that bald, looks to me.
Yeah, and the special prosecutor argues, he says, well, impeachment is an inherently political act and it involves political judgments. And politics, of course, shouldn't play any role in a criminal prosecution. And the Trump's attorneys come back and say, no, any indictment, any charge against a president or a former president is inherently political. So that's a bunch of bull. And in fact, that demonstrates exactly why you should be impeached first. Only if there's been, we're talking about an official act, and only if there's been a judgment then by Congress that you were so outside the pale that you deserve to get impeached for it, should the prosecutors then be able to step in, and the judiciary then step in and say, right, not only do you get impeached, but now you get tried like any other citizen who's committed a crime.
Trump's brief goes even further there, Steve. They make the point, and it's a very valid point, that to be convicted after uh, in an impeachment, the Senate has to vote 2/3 to convict. It's not
Right.
and it's not a,
So it's basically a majority of the representatives of the
yeah,
country
and
agree this is really
two
bad.
thirds of those senators have to agree uh, to convict the president who's been impeached and remove him from office. And the point made is that since it's if we're going to go after a president or former president, there are political ramifications. I don't care who you are or what you say about him. There are politics involved. And if there's going to be politics involved, we want a sufficient, the framers set up a system whereby a sufficient representative, 2/3 of basically
The
the
nation.
nation
Yeah.
is in agreement that he committed an impeachable offense, committed a high crime or misdemeanor. Short of that, uh, the whims of politics on a day-to-day basis could control, you know, the executive, and we the framers don't want that to happen.
Right. Okay. So let's step back for a minute and look at it the case kind of from the other direction. What do we think is the special counsel's strongest argument? Was there any argument that struck you as like, oh wow, the court will really have to grapple with that, or well, Trump's lawyers didn't have a good rejoinder for this? Was there anything like that you guys saw?
Well, essentially, it's two things. One is that it's never it's this is a first impression matter. Uh, no court has found or held that such immunity exists. It's not specifically set forth in the Constitution. So all you strict constructionists should
Right. All you
yeah, you
textualists,
textual
it's
yeah
not in
you
there. It ain't in
it's
there.
not there, so you can't create it out of thin air. You don't want to be legislators. That
Right.
plus the you will hear over and over and again how he tried to overturn an election and upset the constitutional uh, a change of power provisions uh, after elections. Those two things we're going to hear over and over again.
Right. They're going to pound on that. It strikes me as the way that in Nixon v. Fitzgerald, the Supreme Court dealt with this question. And I've mentioned this to folks on Twitter before. It's what lawyers call framing. So Fitzgerald's lawyers in Nixon framed the question as surely the president cannot engage in an unlawful personnel action, right? That doesn't sound right. But the court framed the question as does President Nixon, like any president, have authority to determine how the civil service rules are applied? Right? So they took all of the emotion out of the framing and said the question isn't whether the person isn't this terrible thing terrible? Like, that's not the way the courts need to frame it. They should answer the question of, does this person have the authority to do this? And if so, we really are not that interested in looking at that they might have been enjoying it, right? That they have a bad motive for doing it, or they're secretly, pleased that somehow it's benefiting them personally. Like, we just don't want to get into that. Ship, I see you've joined us now. Did you have something you wanted to chime in
Yeah,
on?
I've been watching, MSNBC all week, and apparently
Oh,
the
no.
best argument that the special counsel has is that accountability must come to Donald Trump because he is a unique threat to democracy. So he
Yeah,
can't have immunity. And after his case, we can adjust all the rules.
right. We'll just go back to the way it was
Yeah.
before. But it's just not going to work that way, is the problem.
Now
That's the problem.
my reaction to, I sort of understand the point of view expressed that post Antonin Scalia and post the rise of the textualists, that Nixon versus Fitzgerald
Fitzgerald.
might not come
Hmm.
out the same way in the court in 2024 that it came out in 1982. And I think that was still, I don't know, it was still a Burger court. It was the very beginning of the
Yeah,
Rehnquist court.
it was still
Okay,
Burger. Yeah, it was still Burger. Rehnquist was on the court, but he wasn't the
right.
chief yet.
So, but it,
I agree. It was only 5
right,
4 even
right,
then. Although, if you really read it closely, they kind of all are saying there is immunity. It's just different versions of
right,
immunity.
and and but and the court acknowledged the Constitution doesn't speak to this, and the
Right.
court
They said they grounded it in separation of
and
powers, which is a constitutional doctrine.
and the
So,
common
yeah,
law. They looked back to the English common
right,
law and pointed out that to the extent we don't have statutory law that contradicts the English common law, the English common law is still a prevailing law in United States courts. And they
right,
found doctrines in the English common law for essentially the immunity of the sovereign, the immunity of the king. And and and
right,
and so they, and based on that premise and the separation of powers, points that you made, they found that a president within his official capacity to the outer boundaries cannot be sued. Okay, up to that moment, the president could be sued until the Supreme Court said he couldn't be sued. In fact, the history of that
right.
case was in the district court, the immunity was asserted and the district court denied it. It wasn't even going to be taken up by the
Right,
DC
by the
circuit.
circuit.
They were going to
Right,
deny the
right. They didn't
application
think that
for
was really a
right.
tough
They
question.
were denying the application in interlocutory
Yeah,
appeal because it was a civil case, so they could ask for
yeah,
interlocutory appeal. They had denied it, and the Supreme Court, on
yeah,
its own sua sponte, cert
yeah.
before judgment, reached down and took the
Right.
case and said, "No, we're
Said,
not
wait a
going down this
minute.
road."
Yeah,
And
right.
so
Although four of them still wanted to,
yeah,
right? Four of them, if you read their dissent, which is what, Powell, White, Brennan, and Blackman, I think, um, are like, oh, well, it should depend. It should depend on what it's
yeah,
about. I mean, can you imagine if you could sue the president and every district court judge in this country could decide whether uh, what you're suing about is important enough to be able to sue the
and
president? That's a recipe for fucking insanity
we'll
right
let
there.
that question percolate up in all 12 circuits
Right.
and bounce
Jeez
around it. And then
Louise.
after we have a good, broad cross section of analysis from all 12 circuits, we'll decide, oh,
Oh,
yeah, there
then
should
we'll
be
decide.
immunity. It's like, so,
Steve and I were talking about this today. That seems very naive in 2024, doesn't it? That whole idea, post Clinton, right? Post Donald Trump president, that just seems to me incredibly
it,
naive. That you could think it would make sense to sue the
yeah,
president
and I
personally.
think part of, and I don't know that there's a justice on the court, maybe Thomas, maybe Alito, that would have this sort of historical perspective, which Steve certainly has lived through. I've lived through to a lesser degree. Kingmaker not spending a lot of time or significant amount of time doing federal criminal law. The scope of the federal criminal law as expanded by
Yeah,
Congress over the
yeah,
past 40
yeah.
years is beyond belief.
Right.
Congress expands the federal statutes just over and over and over again, and it created the need for thousands of more federal law enforcement and hundreds of more prosecutors, and it. But it's campaign. It's law and order is a campaign theme, or was for 50 years. So to now say,
Right.
when faced with the same question in a different arena in 2024 that the Nixon versus Fitzgerald court faced, which is, do we open these doors, or are they better off shut for purposes of our future?
Right.
Given,
For purposes of the government being able to
yeah,
function.
well, we've had a little peek inside, and this is this
Hmm.
is this is the old notion that once you change the rules, they apply to everybody. And I'm
Right.
not a believer in this idea that there'll never be another Republican president. It might not be Donald
Right.
Trump in 2024, but there'll be another Republican president.
Right.
And and
Yeah.
and and
Yeah.
and, and to not have criminal immunity, it's licensed to go hunting.
Well, I'll tell you what, there's a lot of Republican prosecutors in this country. So if I were a Democrat, I'm not so sure I'd be comfortable with the idea that you're going to let any federal prosecutor just decide that they don't like what the Democratic president did last week and charge him. That just seems to me to be
Yeah,
craziness.
at the state level,
So,
we've seen what the Fulton County,
oh my goodness.
District Attorney, properly motivated, can accomplish. You know,
Right.
it,
Right. She thinks that she can, on the state court level, charge a president for conduct that is arguably official or conceitedly official acts of the president of the
oh no,
United
wait,
States.
no,
That
wait, you
seems
got it
like
wrong.
complete
You got it
craziness
wrong.
to me.
Unlawful
No, but go
official
ahead.
acts.
Unlawful official acts. Right, exactly. Unlawful official acts. Thank you, Fannie
Chip,
Willis.
Chip,
Right,
you just
right.
kind of you paraphrase what Trump said. Uh, I'll quote him. His view of the law is if they take away my presidential immunity, they take away crooked Joe Biden's presidential immunity.
Right, he raised that. That was yesterday,
Yeah.
wasn't it? And this is one of the questions that we got on Twitter, you guys, is okay, let's say, we're going to talk in a few minutes about what do we think they'll do, but let's say, for purposes of this question, that the Supremes say there's no immunity for official acts, or it's some version of, well, it depends. We know it when we see it, which is basically what the dissenters in Nixon v. Fitzgerald wanted to do. Okay, does that mean that the current president and the preceding past presidents, whichever ones are still living, really, they're all suddenly subject to this kind of prosecution? Do we think that Jack Smith thinks that that's true? I mean, it would have to be, right, based on his arguments. He might not think that there's grounds for a criminal charge, but could he charge
Well,
Obama?
a cynic might think, not me, a cynic might think
Mm.
that in their little conference room, they look at each other and say, well, yeah, but that suit would have to be brought in the District of Columbia. And what District of Columbia jury would ever convict a Democratic president?
Well, it wouldn't have to be brought. You could come up with some argument for how the effects of the crime, or the wire, ran through the EDVA. I'll tell you what, the jurisdictional and venue case law in the Fourth Circuit that allows the government to bring cases in Northern Virginia that, in my opinion, have literally almost no connection to Virginia, that case law is deep. So, that would be a problem.
You don't need to even go there. Just look at Fannie Willis and her indictment in Atlanta. If the official acts of the president that the prosecutor wants
Affect
to
your
charge
county. Right.
affect your county, then you say, I've got venue right here.
Right.
Yeah, and from
Okay, but
the
seriously, do we think
hold
that
on,
they're,
seriously, from the standpoint of the Supreme
yeah,
Court, you think behind closed doors, they
yeah,
think, look, how would we fix, as the Supreme Court, how would we fix
mm,
an error made in the Superior Court of Fulton County? we would have to wait for that case.
On habeas corpus.
Or we would have to wait for it to wind its way all the way to the Georgia
Yeah,
Supreme Court and then take it as the
right,
final decision of a state Supreme Court.
right, right,
While the mischief plays itself out the entire
right,
path before it gets to us.
right. But people want to know if, in theory, they rule there's no immunity, would that mean that the former presidents were still subject to criminal law? I think the answer would have to be yes. But isn't this one of the reasons why they're not going to do it?
100%. 100%. And
Yeah.
somebody published, I don't know who it was, but it was somebody, it was a left leaning uh, legal commentator, noted, said, you know what, the SEAL Team 6 example is idiotic and we should not refer to it
It
again.
is
It's
it
idiotic.
right.
But
Yeah,
let
you notice it's not
yeah,
in the special counsel's
but
brief.
but liberals need to confront the proposition that Barack
Yeah.
Obama can be indicted for droning a U.S. citizen in a foreign country.
Right. Now, the special counsel said no. They told the district court no. They say that in their briefs too, that they think that was within the scope, presumably because the killing of that U.S. citizen was incidental to the purpose of the drone
Well,
strike.
let him make
Right.
that defense in trial.
Right.
In view of the facts I laid out on Trump's side as to what he was doing, I don't see a difference.
I don't see the difference either. Now,
It,
just so folks know, because people have often asked, well, what about that SEAL Team 6? Why isn't that right? In my opinion, the reason that a president could be prosecuted for using SEAL Team 6, they're probably sick of hearing that themselves, um, to murder his political opponent. So the sitting president murders the person who is nominated from the opposing political party to run against him in the general election. I think that's a private act, not an official act, because it's still murder. And using the apparatus of the government to carry out your personal murder is still personal murder. So it's kind of like misuse of government resources don't constitute official acts. That's a private act. So
I have a question in light of this dialogue. Uh, to what extent did the Biden administration, the DOJ, Solicitor General, all of the powers that be in the administration who decide policy, how much have they had input into what Jack Smith is doing here?
this is a question I have too, and this is one of the reasons I wondered about the brief because I was underwhelmed by the quality of it. It doesn't look like something that the SG's office, although he's got people on his team. Steve, what's the name of the guy that's on the special
Michael
counsel's team?
Dravine, the guy that is the consul of record, is was in the SG's office for 20, 25 years. He's argued 100 cases in the Supreme Court. His specialty was criminal law. He is one of the leading practitioners of a Supreme Court appellate criminal law in the country. So I can't tell you about official blessing, but believe me, the arguments that Smith is making are almost certainly the same arguments that would be made by the SG's office, and the best arguments that can be made under the circumstances.
Yeah.
But I'm talking about the policy of whether they want to go there, whether they want to take the position formally as an administration that there should be no immunity period for any former president, including Democrats.
I see. I've wondered this too. Like if the choice had been up to the SG's office in kind of a normal case, which I guess one against the president would never be, would they have approved this? Because
I think that this administration would have. I mean, look at what Biden has done and look at his general policies, because this is no man is above the law, no president's above the law. And they're not worried that it'll come back to bite them because look at Joe Biden. I mean, in terms of the documents he kept, Robert Hur, who,
well, he's
and
too
I
old to
happen
be
to agree,
prosecuted, Steve. So no worries.
I don't contest Hur's decision, by the way. I think Hur was a professional. But the Democrats seem to have this view that it could never happen to them. And this is, if you want to talk about the special prosecutors, we go back to the history there. Until both parties got burned repeatedly by the special prosecutors.
You mean the independent counsel under the
The
independent counsel
independent
statute?
counsel, right?
Yeah.
Then they finally came around and decided it was a bad idea, only after both had been burned and burned repeatedly. And that's the problem here. It's the whole thinking, oh, it'll never happen to us. We don't have any Donald Trumps in our party. I mean, this just couldn't happen to us.
Yeah, that's probably not smart. Well, let me ask you guys this. Do we think, apropos of Ship's point, do we think there's any possibility the court will overrule Nixon v. Fitzgerald?
I don't.
No.
I don't think overruling Nixon versus Fitzgerald is necessary for them to find against Trump. But I don't. I mean, I think the court's off ramp here is to say the appellate court and the trial court are wrong on the basic proposition that there is never any immunity, because that's the premise of both lower court rulings. So there's just
Right. So people understand. Basically, Judge Chutkan staked out the most extreme position. She said there's no immunity for no criminal immunity, sorry, for criminal acts based on official acts, like in the abstract, divorced from whatever's in the
right,
indictment, which you couldn't have staked out a more sort of simply legal proposition, and that is what the court is
right.
deciding.
And then the appellate court affirmed it 3-0, said she was right, and did not in
Right.
any way trim her sails with their opinion. On that basic premise, they had the same decision. And in the same way that only the Supreme Court could say in Nixon versus Fitzgerald that no, you're all wrong, there is limited immunity for the president within the outer perimeter of official acts, only the Supreme Court can say in a question of first impression that the president has some immunity for conduct engaged in while he was in office that's related to exercise of the powers of the office. But because there's no factual record below, because nobody took the time to
Right.
actually decide what the individual instances of conduct were that were disputed between the two parties.
Whether they were in or
Right.
out in terms of official acts.
The Supreme Court doesn't make new record. The Supreme Court only deals with the record that's brought to it. So the easy off ramp for the court here is to say the lower court is wrong, the lower courts are wrong, but that's as far as we can go because there's more work for you all to do before we decide whether the limits that you settle on are correct or incorrect.
Now, we've been saying this for months, the four of us, that really there needed to be more fact finding by the district court, and she needed to apply the principles of immunity to that fact finding. And that wasn't done. And it seems like, Ship, from some of the tweets we saw, that some of the liberal commentators have finally come around reluctantly to the conclusion that we've been talking about for months and months, that that's probably what's going to happen, that the court is probably going to say there is immunity, but nobody's bothered to tell us factually what's an official act and what's not. And since nobody's done that yet, Judge Chutkan gets to do it now.
Let me ask Steve a question. Let me get to my hobby horse that I've had since day one on this
question. Is this about this question posed?
No, this one is about the accepted standard of review on a motion to dismiss, which is you assume all the facts in the indictment to be true. That cannot be the standard of review for a motion to dismiss based on immunity. She can't just accept all the facts as pled to be true. And she did that. She said that was the standard of review, and the appellate court said that was the standard of review, but that's a self-fulfilling outcome. Because
and Smith has conceded in his pleadings that his indictment covers facts that are quote unquote official. So
But if you go back and you simply the point I've made, and I guess I should make it those terms again, is that standard of review leaves the question of immunity at the mercy of an artful prosecutor in crafting the allegations.
Right.
And it doesn't get to the actual fact of what happened and where the boundary is.
Ship, Smith has taken an interesting turn on that point.
Right.
He does not. First, he can, as Leslie says, he concedes that certain of Trump's acts were within his official duties, but he says we don't need an evidentiary hearing on that. Send it to the jury and basically
Right.
give
Right.
the
Let
jury
the
instruction.
judge make findings and give the jury instructions.
But
Okay.
issues of immunity are a question of law.
Right,
They're
I know.
resolved before juries even impanel. They're questions of law.
Right. Right, I know.
But Smith wants to make it a after the trial question of law. Let the jury find the facts, and then apply the law.
But no,
Right. So we're going to get into
but no
Steve's
immunity.
thing about
Right. But
mobocracy.
no
Right.
immunity question
Right.
is resolved on that basis. Every immunity question requires fact finding by the judge. That's why when it goes up, the judge's findings of fact are reviewed for clear error, and questions of law are reviewed de novo. So she would have to make findings of fact. Yes, she's not supplanting the jury. That's part of the process of establishing or evaluating an immunity claim.
Right. So what are we to make of this suggestion by Smith's brief that that's the way it should be handled when it's perfectly apparent to anyone who knows anything about this area of law that that is never the way that it is handled. And so why in the world would you even suggest that?
It's a transparent effort to get this case tried before the
Before
election.
the election. Right. Okay. But the Supreme Court is not going to say, oh, yeah, you're right. We should let juries decide immunity issues. That totally makes sense. They're just not going to do that. So why would you be dumbass enough to put that in your brief?
Exactly. It's a credibility frying argument. And it,
They
Yeah.
put it in their brief because they had to put something.
Well, that's probably true. They got to
Steve,
say
no,
something.
I've been there and done that, so I
uh,
understand why they did it.
I do not. I disagree. The something they could have done was if you're going to hold there's some immunity that Trump is entitled to claim, uh, spell out the test, send it back to the trial court. We'll have a quick, but it only takes a week to put on the evidence as to the extent of that immunity, and then we try everything else. That's what he could have said, should have said.
Right. But
But
instead, he said this, which is nonsense. Right. No, I know. That's one of the reasons I was like, this brief, I don't know about this.
Well, I disagree with King on that because you say spell it out quickly and then we'll try everything else. No, they're not prepared to try everything else. They want to bring in the official acts at least as evidence, and their brief makes that clear. So if they go back, if once they concede that there has to be an evidentiary hearing and findings made, those would be subject to an interlocutory appeal again
Another appeal, you
coming
guys.
up right through the DC
Yeah.
Circuit and to the Supreme Court, and they are desperate to get this case tried before the election. Although to me, it's perfectly apparent at this point that that ain't going to happen.
Right. So let's turn to that for a second because but it still raises the point of why you're just saying stuff to the Supreme Court that they're just going to roll their eyes at. So
but
that to me is dumb advocacy.
it more than that. It does it accomplishes or it tries to accomplish what Steve just articulated, but it's so transparent
Right,
that
exactly.
it
It's useless.
you have a great big hat you just put on your head that says
I'm a
political.
I'm a dum
Political.
dum. Right.
Yeah, that's a lose.
well,
Right. That's
that
hilarious.
was my point, that it's a credibility frying argument.
Yeah, right. Destroying. Credibility destroying. I'm not sure that people can hear that. You're saying frying, as in frying pan. Credibility frying. Yeah.
What you need, and we had a recent example in terms of the case, Mark Meadows' case down in Georgia in the federal court there, where he claimed that he had immunity, and the judge had a factual hearing on that. And that's the sort of thing you'd be talking about here. I mean, that's what you're suggesting, Bill, and I agree with you. King's agreeing. We're all in agreement on that. That's what you need in order to make a determination whether the acts at issue in the indictment were private and therefore subject to prosecution, or official and therefore covered by immunity.
Right. Speaking of like specific points in the briefs, did you guys notice how many times Trump's lawyers cited that article by Brett Kavanaugh? I lost track of how many times it appeared. Did you guys notice that?
Yes, you're referring to the University of Minnesota Law Review article in 2009.
Yes, exactly. Oh, we
Yeah,
lost King. Yeah, that made
yeah.
me laugh. I was like, all right, well, just,
I'm not sure though, because I took a brief look at some of the commentary on the article. I confess I haven't read the whole thing. It's not clear to me that it's as much in their favor as they think it is.
aha, okay. So it seems like a pure pander to his,
Yes.
this is what you already think, Justice, and we know it and you know it, so,
Man,
okay.
Yeah,
All
but
right.
I don't think Kavanaugh went that far in the article.
Okay.
and I don't know why lawyers do that. I really don't, because
I don't either. It's a
well,
bad look.
Kavanaugh knows what he wrote. You have to,
Yeah, he knows what he thinks, right?
and he will share it in, if they are circulating, memos among the judges in the aftermath, either before or in the aftermath of the argument. He'll share it. I mean, to me, yeah,
Right.
that's just that's something that does not need to be said and looks bad or looks worse when it is said. On Steve's point about that it would only take a week, but having earlier said correctly, but it would be subject to interlocutory appeal because you're still talking about the scope of immunity and whether it applies and whether there should even be a trial. That would have to go to the circuit. Now, if the Supreme Court thought the circuit got that right, they wouldn't have to take it up. But they're also, the calendar is there are competing claims on time on the calendar, and I still am 100% convinced that Judge Cannon is just laying in the weeds while that New York case is up there, and she is going to monopolize the calendar through the summer and into the fall, and not make time for anything going on in D.C. And she's going to, threaten Smith with contempt if he does not do everything in his power to avoid calendar conflicts.
All right, so let's talk about that for a second. So let's assume first we'll talk about without Judge Cannon and then we'll add her into the mix, okay? So let's say, well, let me ask you guys this. Do you think that this case will be decided early between now and the end of the term or toward the end of the term?
This case is highly controversial, and it will come down, I think, at the end of the term.
Yeah, I agree. I don't. It is not going to be 9-0. There's going to be. Yeah, it might be 9-0 on the outcome. It'll be the
Right.
rationales and what they think should happen in the lower courts are going to be very fractured. Might not even have five on the rationale. Um, and then so all of those opinions have to be written, and
Right, which takes
yeah,
time.
and you can't be issued until all the opinions are ready. Um, and so yeah, I don't. I mean, there's not a lot of time left, and there's still like 40 cases left to be reported.
Right. They still have a lot on their calendar that have to be finished before the end of June. King, are you in agreement? You think it'll come
Yes,
toward the
towards
end?
the end, because, and I agree with Ship. I think we could see as many as four opinions.
Right. So I'm going to talk about what we think they're going to do in a second, but let's stick with the timing here. So let's say they rule that if they rule there's immunity for everything, which they're not going to, then the case is dismissed. I don't think they're going to do that. So let's set that aside for a second. If they rule there is immunity and it covers official acts, but fuck all if we know what those are, so you guys figure it out in the trial court. Or if they rule that um, that there's no immunity and that the whole thing can go forward, then the case is going to have to go back to Judge Chutkan either way. So let's say they rule on June 30th, and then let's see, how many months does that leave until the election? July, August, September, October. Basically 4 months and a couple of weeks, right, until election day. So do we think there's enough time in there for Judge Chutkin to hold this 1 week hearing that the special prosecutor will swear up and down can be conducted in a week, and then get her rulings, findings, and decision, and then appeal that to the circuit, and then the Supremes either hear it or decline it, and then go back to Judge Chutkin for a trial between June 30th and November, whatever the date of the election is.
No.
No.
Right. Yeah.
Remember, she's already said Trump's going to have another 88 days of preparation time before jury selection. So when does
Right.
the 88
And
days begin? Now will she?
when is that going to be?
But let me go farther and say this. Suppose that the Supreme Court were to affirm and say there's no immunity, which I think highly unlikely, but suppose that for the sake of argument. They say that on at the end of June. Then that means, based on what Bill just pointed to, that the earliest Judge Chutkin could start the trial would be the end of September, start of October. And it's estimated to be, what, up to a 12-week trial? At least that's what I've read. That means that you'd be putting Donald Trump on trial the month before the election, and it would be his second trial after he's just stood trial up in New York,
In New York.
On the Alvin Bragg fiasco. It seems to me, and I have no question that Judge Chutkin, absent the current appeal, would have been prepared to start trial as she had originally scheduled, which was what, at the end of March, start of April.
No, it was supposed to be March 6th.
Okay, start of March. I mean, if she could have held to that schedule, she would have. If she was going to be the first trial, she would definitely have marched forward. But I think that even as hard over as I see her as being on forcing this case to trial, that starting this trial at the end of September, at the start of October, might be a bridge too far, even for her.
You couldn't finish before Election Day, right?
No, you'd be keeping Trump locked up in trial in D.C.
in the Prettyman Courthouse instead of out on the campaign.
Right, right.
Yeah.
And you want to talk about political prisoners? I mean, I happen to think that this whole business about the January 6 people being political prisoners is hooey, but there'd be a lot more substance to it in terms of Donald Trump being confined in a D.C. courtroom in the month leading up to the 2024 election.
Yeah, and on top of that, I think that's exactly right. The silver bullet for the Democrats has been a conviction of Donald Trump.
Right. How could they even accomplish that before the election? I don't think that's possible.
The lawfare being waged against him has, to their shock, worked against them politically.
Right. It's helped them at the polls.
And so Steve's description of essentially pinning him to a chair in a courtroom through the entire election season, basically, that without getting the verdict would, it's like nitrous oxide into an engine. It would so.
When is he supposed to prepare for the debates and all
that
this
would
stuff?
all be off. None of that
Jeez.
would happen.
Right.
Simply because one judge decided that she was going to start a trial she couldn't finish in the middle of the general election season.
Right. So, but Bill, you seem to think that even that couldn't really happen given what Judge Cannon, the judge in Florida, will do.
Correct. I mean, she's got a whole series of unresolved issues that require hearings. And there's further briefing on all the CFA issues still to come. The defense has not even gone through their CFA rights yet. What we've had so far is the government's, CFA filings about, how.
Right. So people know CFA, what he's talking about is the classified information. There's a statute that governs how that stuff is used in courts. And so Judge Cannon, because of the nature of the charges in that case, is having to plow through that statute with both parties.
Yeah, and each side basically goes through a series of filings about, classified documents that they want to be able to use, and the other side responds to why they want to use them, whether they should be able to, and then the judge has to make the decision. But the prosecution goes first, and then the defense gets to go, and they're all under seal. And she has obvious no urgency attached to the way she is managing her case.
There,
She, Judge
there,
Yeah,
there,
Cannon. Yeah.
let me interrupt a minute. There is a recent development in that. Uh, this past week, Trump's lawyers in the Florida case uh, filed a motion with Judge Cannon to extend the May 8th deadline for Trump to designate what classified documents he intends to use at trial or in his defense. Uh, they want to move the May 8th deadline until uh, I think it was three weeks. I may be short there, but a number of weeks after the conclusion of the New York case, because it seems Mr. Trump and his classified documents primary lawyer are both otherwise engaged.
Oh, they're a little tied up in New
Yes.
York? Yeah. Hey, Ship, remind me, because I don't know off the top of my head. What's the date that Cannon has for her trial currently?
it's vacated. She doesn't have one. And
Oh, she finally
there
vacated
yeah
it? I missed
there's
that.
a well oh, actually it was May 24th, but I think she vacated it already and had well no I take
Okay.
that back. It's still May 24th, but she had both sides brief alternate
Right.
dates, but I don't think she is
Right.
not
I didn't think she had technically moved
right
it
she has
yet.
not
Right.
reset it yet. And on King's Point, um, he described that exactly right. And then the special counsel came back with a retort that said, well, he didn't have to hire the same lawyers for both cases. It's like,
Right.
whose business is it of that? He has a Fourth Amendment right in criminal cases to counsel of his choice.
And not only that,
Right.
to designate the classified documents, Trump and his lawyer, if assuming Trump wants to be there, and I don't know why he wouldn't, have to look at the documents in a skiff in Florida.
In Florida, right? They're all in Florida.
they, they they can't put them in their suitcases and take them to New York to look at after hours during the New York trial.
Right. Because that would make
Yeah,
sense
well,
also. I mean,
as a
ugh.
lot of people, I think some people know here, one of the defense lawyers in that case, representing co-defendant Walt Node as Stanley Woodward, is a good friend of mine. Stanley flies to Florida pretty much every week from Tuesday to Thursday because he has to go to Florida to the FBI to view the documents in the skip. They cannot be viewed anywhere else. Judge Cannon ordered that all the documents be moved from D.C. because the case wasn't venued in D.C. to Florida. So that's where they are.
Okay. All right.
Um, uh,
So,
uh, uh, and I want to weigh in here with something that the participants in this call all know, but I just want to say for the benefit of the audience. If you're a lawyer, much less a defendant, but if you've ever been in trial, a trial is all consuming. The notion that you, while you're in the middle of one trial, could be spending the evening, your free time, on something other than the trial that you're involved in is utterly preposterous. A trial is an exhausting ordeal in which you spend all of your time for however long you're in trial singularly focused on that trial.
right. You're working 18, 20-hour days. It's all
Yeah,
consuming.
I will. I mean, maybe all four of us who are talking here could offer our essential, what our habits are. When I'm in trial, I'm up at 4 a.m. and I work at my desk for, 4.5 hours. When my feet hit the courtroom floor, I've usually been up 5 hours. And then, you get through the trial day, you're done by 4. Well, then you're thinking about, okay, what's happening tomorrow? I'm good till about 8:30 or 9 p.m. and then I'm just fried. The motor is turned off. A couple hours to decompress and then 5 or 6 hours sleep. That's about it. And then back up at 4 a.m.
Right. When I've been in trial, the last two trials I've done, I don't think I got more than 4 hours of sleep any night during the trial. You don't have time. You're lodging objections to the new documents that showed up today. You're going through the transcripts still for a witness who testified, said things that, that's different from what they said before. The judge wants briefings on a new issue that's come up. You got a problem with a subpoena or a witness. You're still prepping witnesses. There's no time to do anything. Literally, the last two trials I had, I took a hotel room near the courthouse. I didn't live at our house during those trials because you don't have time to eat. You don't have time to do anything other than that client's case. That's it.
You order uh, room service. You
Right.
hole up at a hotel, room service
Yeah.
day and night.
You don't see your
Yeah,
family.
no fair.
Right.
Witnesses are lined up. I put witnesses up in a room next to me so I could
Right.
be near them. We interview and talk and get them prepped. And
Right.
it
You got to go over with the client what happened
yeah.
that day, problems, issues. It's just there's no time to do anything else, literally.
And
So,
it just
the idea that, oh, well, his lawyers can do both is just
well,
absurd. The
and,
judges know
and
that. That's
right,
absurd.
and the comical thing about that argument is it was made by Jay Bratt, DOJ prosecutor, who's obviously not
Right.
involved in the Alvin Bragg case in New York, and he's not involved in the DC case. He's a
Right.
special counsel prosecutor dedicated to the Florida case. Well,
Right. He can spend all
yeah,
his 24 hours every day on that case.
exactly.
So,
It's
good
like,
for him.
well, Donald Trump's rich. I guess he sort of just hired, 8 lawyers for every case, and then, he could have just had Zooms with the different groups, whatever necessary.
Right. I mean, the judges are working almost as
Yep.
hard during the trials too. They're not stupid about that. So that's ignorant. Well, okay. So we've been going here for a couple hours, and I've got a few more questions to cover, but I didn't want to go too much longer than usual today. Let me ask you guys this: result from the court. We expect it to be what we said a few weeks ago, that they will find that there's immunity and likely have to send it back to Judge Chutkin for some kind of factual findings. Do we still think that's what's going to happen after Thursday?
Yes.
Steve, you got to unmute yourself. I can hear you, but nobody else can. Steve, you're still muted. Ship, you want to go?
I said,
I can
no, no,
hear Steve
yeah.
talking in the other room,
I said yes. I
but
said
he's
yes if you didn't hear me.
okay. Hold on a second. Let me see what's going on with Steve's thing here.
I agree.
Aha, there you go. Now you're unmuted. Okay, so all these articles are saying, oh, there's no way the justices are going to do that. They might decide 9-0 that there is immunity, but not say what parts of the indictment it applies to or doesn't. And I don't know. I'm a little worried about what the lawyers on the left will do if even the liberal justices kind of do what they did in that Colorado case, right? And say, well, as a principle of law, yes, there's immunity, but we're not going to dirty our hands with exactly how that applies to Trump.
Well, it's not going to be that way. I predict that 2 or 3 of the justices, the liberals, will agree with the DC Circuit that there's no immunity. I don't see all 9 justices agreeing that there is immunity.
Okay. Well, I'm not saying that will happen. I'm saying it could, but I agree with you. To me, it's going to be basically 6-3, 7-2, or 9-0.
But the principal part though will be I think we're going to see a blanket statement of what the law is apart from Trump. They're going to announce
Right.
something that will prevail, Trump or no Trump. It's going to, for all time, this is going to be the law.
I think that
Right. Which is why I think there's a possibility that all of them agree. But go ahead,
I
Ship.
think that would be a very interesting and astute approach to the outcome, is to minimize the use of Trump's name in the opinion,
Right.
and make it clear this is about the office and the future.
Right. It's about the presidency, not about this man. Right. So, all right. Well, we'll see. Okay. So let me see if we've covered all the questions. Oh, one of the questions we got was, what are they going to do about this kind of blurry line between official and campaign. Do you think they'll give any advice about that?
No.
Yeah, that's that. I think that goes back to the trial court, my argument has been there that there's the unique aspect of the presidency is it's not a hat on hat off kind of position. It's 24/7, 365. There's nothing that a president does that he does in some capacity other than as president.
Right, with this caveat about private acts, right? He can be the president all he wants to. He still can't shoot the vice president.
Oh, I don't disagree, but even everything Trump did was, it was.
Well, there's an argument that it's all official, but the other side wants to say no, but that's personal because it's campaign related.
Well, I can see.
Right, and there's decisions in DC on the civil side saying that he doesn't have civil immunity on these because he was engaged in political self-interest, not in official acts.
Right. So I don't know if this court's going to offer any advice as to how Judge Chutkan is supposed to sort that out. Maybe they'll just let her take another run at it once they straighten her out that there is immunity there. I don't know. That's one of the things I'm looking for. Are they going to give any advice or guidance to the lower courts at all? Okay, the documents case in Florida. We've been talking about Judge Cannon. So one of the questions we got was several questions talking about how is this going to affect that case. So to the extent that that case is relying on acts that are also official, which I think there's no question that some of them are, it should have the exact same effect, right? It should force Judge Cannon into holding a hearing because didn't she already deny his motion to dismiss on grounds of immunity?
Leslie, you need to explain more because with the Cannon case, that's based on the records, and most of that looks like it's after he left office. So to the extent you're talking official acts, it's got to be while he's in office. You need to explain why there is part of the indictment that covers stuff while he's in office.
Right. It's sort of the taking of the documents themselves have to occur before he left the office of the presidency, right?
I think
Packing
at
them.
the hearing, Smith even admitted that. He said
Right,
he
he
said
did. He
these
conceded it.
documents were boxed up and removed from the White House when Trump was still president.
Right. I mean, by logic, it would just have to be. They didn't fly to Mar-a-Lago after, right? So, right. So there's at least a sliver of that indictment that also arguably it constitutes official acts. So, but Ship, am I right? Do you know, or King also, do you know? I thought Judge Cannon had denied the former president's motion to dismiss on grounds of immunity
I
also.
don't think she's ruled yet. I think it's pending.
I,
You don't think she's
I
ruled
don't
on
think
it?
she's ruled
Pending.
either
Okay.
because we're only talking about a sliver of the conduct that happened
Right.
when he was president, and that really didn't get focused until they had the last round of arguments.
Okay, I'm not following that case as closely as the one up here, as you guys can see. So, to the extent that Judge Cannon has not yet ruled on that, then obviously whatever the Supreme Court says in terms of official acts and immunity will go into that analysis. That probably the parties will give her new briefing, right, based on what the Supreme Court decides, and she'll be able to take their decision into account then. So it could be that it has some effect in part on that case. Although the taking of the documents itself to me has always seemed like one of the central facts of the case. So we'll see what happens there. It will be, I think, messy in the DC case for Judge Chutkan to have to sort out what's official and what isn't. And I just don't have any belief that that could be done within a week. I just feel like that's something that will take a long time with detailed fact findings submitted by both parties, and the judge will have to choose between them and then apply the law. Smith's got what, three different kinds of conspiracy, three different theories of violation under 1512 alone, right? So, which is the obstruction statute. I just see that as a very time consuming activity. What do you guys think?
I agree with you. I had
Yeah.
another
Okay.
question while we're
Yep.
all
Go ahead.
together.
Yep.
Any chance that a Democrat majority Congress next term may try to take up the Supreme Court's decision in the Colorado case by passing a new statute as to the 14th Amendment?
Oh, you mean if they, you mean after January 1 of 2025 with the new
Yes,
Congress, if assuming that the Democrats control the
but
House.
not the presidency.
Um, right. I mean, possibly, right? The other thing I wondered is, I, I don't think, do you guys know differently? I don't think there's anything that would prevent a Congress, not the one currently in seated, but would prevent a Congress from impeaching a former president who's no longer in office in order to disqualify him from office. So if the court says, well, yeah, in order to prosecute him for official acts, he has to be impeached and then convicted, and then you could do it. Might they try to take that up,
Uh,
as you're saying, King, in the next
Yeah, no
Congress?
way they would get 2/3 uh, of the Senate to convict.
Right.
But
To be successful, I agree.
but
Uh,
But
uh,
but to be
could that be
successful,
done?
they only need a majority to pass a new law that implements the 14th Amendment before
Right.
inauguration day.
And then try to
okay,
disqualify him as an insurrectionist. Yeah, Steve, what were you going to say?
what, to pass a new law between now and January of 2025?
No, he means after the new Congress comes in to be is sworn in on January, whatever it is, 3rd or whatever, next year, after the election in November, new Congress in January, and then try to pass a statute before, assuming Trump wins the election, to pass a new statute before January to prevent him from taking office on January 20th.
No, no,
How would they even do that? He'd have to sign it. Well, Biden would have to sign it, right?
no.
So,
Well,
yeah.
and I mean, I think that's a very real possibility. What have they shown themselves unwilling to do?
Yeah, well,
And
that's
they would
true.
need now
Yeah.
they would need 60 votes in the Senate to get past filibuster unless they get a couple of new Democratic senators and they maintain 50 who say, I'm not Kristen Sinema, I'm not Joe Manchin, I will vote to abolish
Mhm.
the legislative filibuster.
Okay, and what do you do then when Trump's new attorney general says, "Aha, I'm going to indict you, Joe Biden, for having done exactly what you accused Donald Trump of doing
Yeah, but they
before"?
just prevented a Trump attorney general. They just said Trump is disqualified. But then the question becomes who becomes president.
Who's the
It would
president
be
then?
it would be Trump's vice president, and then they would be in the jackpot
Yes,
you're talking about.
yes,
Right. Right. Yeah.
Yeah,
yeah.
that was my scenario. I was just curious as to whether anybody thinks
Yeah.
that's possible.
I mean, it's crazy. Is it? I suppose theoretically, yeah, it's possible. Either way, they could try to either impeach Trump and remove him, or disqualify him before the inauguration, or try to go under the
No,
14th Amendment and find him, disqualify him
the,
that way.
the Supreme Court having spoken, that's not going to be acceptable. I'm so, maybe I'm too sanguine, but I take a longer view on all of this. This is, I've been around for a long time. I was a kid when Brown v. Board of Education came down. Um, but the fact of the matter is that this country complies with Supreme Court decisions. They grumble about them, they gripe about it, they try to overturn them, and in the case of Roe v. Wade, after 50 years of agitation, sometimes they manage to do it. But I don't see them turning on a dime. And if there's Supreme Court decisions that are favorable to Trump, trying to undo them in less than 30 days in January of 2025, that ain't going to happen.
Well, it just occurred to me because of this argument in Trump's lawyer's brief about that the impeachment is the only, exception to the immunity. And the idea that, well, so you could hold the president accountable that way, and therefore you're not high and dry. One of the counter arguments is, well, but what if you can't manage to get your act together and impeach him, um, before his term runs out? And which caused me to wonder, well, does he have to be in office? Because the impeachment goes not just to removal, but also disqualification.
I don't
So
think you can do an impeachment just for disqualification. If you're
that was
talking
my
about someone,
question.
yeah,
That was my question. What would prevent that?
because I think that the whole purpose of it is to remove a sitting president. If you're talking about a past president, it's inapplicable.
Yeah, but I'm not sure if that's right or not. I've never researched that point. So,
Let me ask this
um,
question. Let's assume that there is a Democratic House that could sponsor a bill of impeachment, and regardless of who controls the Senate, but there is a Republican vice president who would take over the office. Does that create a scenario where you do get 2/3 of the Senate?
well, I want to think about that for a second. Here's the actual language, and have you run that out again, Ship, because I think I might have missed part of it. So the language in the Constitution is the same one we looked at earlier today, Steve, that you read to us. But it's the first part of it. It says judgment in cases of impeachment shall not extend farther than to removal from office, comma, and disqualification to hold and enjoy any office of honor, trust, or profit under the United States.
Right. And so, in my view, that means that unless you've got the primary objective, removal from office, you can't do it just for the secondary objective.
Right. Boy, we'd really get into some textual analysis and looking at what the framers thought and the drafters. What does that comma mean? More grammar, you
But
guys.
you talk
Yeah.
about the politicalization of
Yeah.
you know that,
Right.
that
I know. The country would go crazy. So, Ship, what's your fact pattern again? I missed part of it.
Let's assume that the Democrats take over the House, and so now they can
Right.
return articles of impeachment, and that
Okay.
goes over to the Senate. But Trump has been elected, and the Senate knows it would be a Republican vice president who would take over in the event of Trump's removal. Do you get 67
Right.
votes? You might.
I'm sorry. I'm
it,
not following you. Why
it,
might you?
I'm sorry. My reaction to that, my friend, I mean this sincerely. You're a wonderful lawyer. But the bunch of us are just lawyers. We're not politicos, and that would make a good novel. But I don't see it as
I
political.
didn't
But the
realize.
calc,
Hey,
but the
Ship, are you positing that they take over the Senate too?
no, no,
The
no,
Dems
no.
have the Senate?
It wouldn't
No.
be necessary. The question is, do you get 20 Republicans to vote to remove him, knowing they're going to get a Republican vice president in the
Oh,
office?
I see.
No,
Whoever his vice
Right.
president
With
is. Let's say
and have to
it's,
go back
yeah,
and face their constituency.
Yeah,
constituents.
but
Yeah,
maybe not for 4 or 6 years, depending on who it is.
I see what you mean. Right.
There would be
That
a sufficiently long period of time that the new president the former vice president, new president would have to demonstrate that the party can move beyond Donald Trump while still following some of the policy preferences of Donald Trump.
Well, that would be interesting.
I think we ought to stick to the law, not the policy.
Not novel writing. Okay. All right. Let me see if there's anything we've missed from the list of questions. We had a question about, will the justices be worried about the reflection on them of finding immunity in this case?
No, all of their decisions reflect on them. This is an important decision, but they don't sign their names up to something worrying about the public reaction to it.
I think they proved that in the Colorado case pretty much, right? They quote unquote ruled for Trump in that case because they just think that's what the answer is. So, okay, let's see. All right, and then this is the last one. We had a question about, okay, let's say that the Supremes do say there's immunity. and they've set out, they use the test in Nixon v. Fitzgerald that it's whatever's within the outer perimeter of the president's official duties or official president's powers constitute official acts. Okay, but where is the definition of what that is going to come from for in order for Judge Chutkan to apply it? And if that's not at all unclear, then what's the situation in terms of like what's the default? Who gets the benefit of the doubt? So where is she going to look to if the Supremes dump it back in her lap to say, all right, well, you figure out what's official acts and what isn't?
She's going to look at the decisions that have been made in the civil context to which I referred earlier.
Yeah.
And they've decided
She's
that
going
some
to
of
be
this,
bound by some of those because they're from our circuit, right? So,
well, yeah, they're in the civil context, not the criminal. But she'll look to those, and the courts concluded that Trump was doing political things, not official things, and that's what she'll rule. I think that's perfectly clear. And then it'll go up, and the circuit will say, yeah, we've already decided this, and then it'll go to the Supreme Court, who will say, well, okay, it's very interesting what you thought, but here's what we think.
right. So just so people understand, in this kind of analysis, the judge is going to look to what the law is that's previously been decided. So in terms of whether a default or who gets the benefit of the doubt, it's not like fact findings in criminal cases where you have to prove beyond a reasonable doubt, right? Or even like the rule of lenity, where if it's ambiguous, it goes in favor of the defendant. When judges are doing this kind of analysis of what's within the scope of your duties and what isn't, they they think that they're doing sort of objective legal analysis and there's not a lot of like default kind of
Can I
analysis.
ask Steve a question? Yeah,
Yeah,
Steve,
sure.
what was the support or the evidentiary basis for those DC cases, the civil cases?
I'm not thoroughly familiar with the details, but I know that that's where what they've concluded, King.
Did, did they
Um,
have a full-on evidentiary hearing?
I
no,
think
I don't think
that
so.
they didn't. I think they just proceeded on pleadings. But we could go
But
back and look at that. Yeah.
I know for a fact that one of them came up, I think, through Judge Maida at the district court level,
Yes.
and Maida, he's a Democratic appointee, but he is a very bright and thoughtful guy, and sort of, I would say, relatively middle of the road. Um, Said that the stuff was not official. Now, I'm not sure that I personally agree with him, but this is a decision by a judge that I have a regard for, and the circuit came out the same way.
Yeah. Now, I read those at the time when they came out, King, and I didn't agree with them. I thought these decisions are hopelessly infected with what these people's views are of both the former president and the January 6th event.
There's also distinctions in some of the allegations, but
Yes.
I listened to most of the DC bar's evidentiary hearing on the complaint to disbar
The ones against Giuliani?
Jeff Clark,
Oh, Jeff
and
Clark.
there
Okay.
is nothing he did that happened outside of the confines of either the White House or the offices of the DOJ. Uh,
Right.
Everything he did was during his daily work at the Department of Justice.
And
Right,
stuff they're tasked to do. Their whole point seems to be you were trying to overturn the election, so therefore it doesn't matter.
right. I, King, I agree with you. I think the whole thing on Clark, and I don't agree with Clark. I'm not a fan of Clark, but I think that the notion of trying to disbar him based on the position he took internally on this is ridiculous. And I know Phil Fox, who's the bar counsel and therefore the prosecutor in the case. I've known Phil for 40 years. He was a prosecutor. And he's a smart guy and a very good attorney. But I think that his position is gone. I think he's gone around the bend in terms of his position in this case.
Yeah.
But it
So,
it kind of stems from the January, the J6 hearing, the committee hearing on that,
Yeah.
and then their findings regarding that episode. But Smith has put it in his charges against Trump, accusing him of conspiring with Jeff Clark,
With the
with
Department of
the
Justice.
exactly, and
Right.
which
Yeah.
is difficult. It's problematic from a presidential immunity standpoint. So
Yeah, it is.
Right, right. I think, right. I'm with you. I agree that even from the lawyer's perspective, if you look at it from Clark's perspective, it's wrongheaded. But if you look at it from Donald Trump's perspective, he's not a lawyer, and he's got he's got different lawyers from DOJ telling him different things, and not surprisingly, he likes the view that favors his position.
except that he did not take Clark's recommendation. He didn't send the letter, and he didn't appoint Clark the acting AG.
That's true,
So he got talked.
because
He was talked out of it.
because the other
Right.
you're right. The other people pushed back so hard that he decided against that, and I think that that's an excellent point. Donald Trump likes to pit people against each other. He's not a lawyer. He listens to these people going back and forth, and he decides at the end of the day not to go with Clark's suggestion. But nonetheless, he and Clark are now co-conspirators in the view of our special prosecutor, Mr. Smith.
Right. All right, guys. So, is there anything else we want to say about what we're likely to hear on Thursday, or about the briefs to help people understand what's going on? Because I feel like we're winding down here.
Yeah, I think I'm done.
Okay.
I'm
King?
astonished to hear that.
Well, hold on. I'm done unless you want to go to dinner.
Are you here?
No,
Are you
no,
local to us? No, you're
I'll
not.
be there
Yeah.
next week. So maybe we ought to put that on the calendar
Okay.
for next week.
Yeah. We can have dinner next week. Yeah. All right. King, how about you?
No, I'm done too.
All
I'm
right.
about to doze off.
Yeah. All right, you guys. So, overall conclusion is probably the Supremes are going to say that Trump has immunity, in which case, various people's heads will explode. But probably also the case will go back to Judge Chutkin for her to make a more detailed analysis of that question. We think it's unlikely that the Supremes will parse through the whole indictment and say what's in and what's out. And then we also, I think, all agree that that's extremely unlikely to happen in any meaningful way before the election. So that's where we are, and then we'll see based on Thursday, at least partially, we'll see, how we're doing. As usual, I'm going to be talking about that case on Twitter. I'm going to try to live tweet it. That's very difficult to do. It's hard to listen to them, encapsulate what they're saying, type it all in, and keep listening. But I'm going to try to do that on Thursday so that people can, in real time, keep up with what's going on. But either way, I think that we'll be talking about it again. Not on Thursday night. I have something else to do Thursday nights. So maybe next weekend we'll reconvene and talk about how we think the argument went. So that's all for tonight. Thanks, all you guys, of course. Chip, King, Steve, thanks for your input. And so I'll say good night.
Good night.